Dear online guests, dear students here present in the feestzaal of the Law Faculty of Maastricht University, I welcome you all to this second lecture of the lecture series Strengthening EU Environmental Law, Legal Perspectives on Greening Europe. Our speaker today is Professor Fabrizio Fracchia from Bocconi University in Milan. He is invited because of his research and his writings on environmental duties, so the duty to protect the environment. Putting an emphasis on duties and exploring them for their value to protect the environment, I think he makes a very important contribution to the discussion on the legal debate about, well, the trending theme, providing rights to nature. The lecture will be delivered online from Italy, and it will last for about 45 minutes, after which discussion will take place. The lecture will be recorded, the discussion not. Professor Fracchia, you have the floor with your lecture on the duty to protect the environment, which has the fabulous subtitle From Anthropocentrism of a Right to Anthropocentrism as a Duty Towards Future Generations. So you can share your slides with us and take the floor to deliver your lecture.
Thank you. Good afternoon. Thank you for your invitation. A special thanks to Marjan Peters that I had the pleasure to meet in my university in Milan, in Bocconi. It's a pleasure and an honor to be here and to meet so many people, even if online or in online mode. Hoping that soon we will have the opportunity to meet in person. So the subject and the topic is the duty to protect the environment, this different perspective. The thesis that I would like to explain, to suggest, is aimed also in a provocative way at debunking three myths by showing that the environment is not a right, as already mentioned. The second point is that the purpose of the regulation in this branch of law, environmental law, is not to protect the environment itself, but the human species. This is a second and provocative perspective. And the third point, we are talking about a more comprehensive sector of law, in my opinion, the intergenerational responsibility and relations, which includes environment, of course, but that has a bigger area. Of course, at the beginning, we have to consider the problem of the legal definition and the legal qualification of environment. The qualification has to do with the attitude of the law towards the environment, in which sense is taken into account by the legal system. For example, the environment can be considered as an object of a subjective right. This is the most common perspective. The definition instead concerns the identification of what the law considers and regulates as environment. And the two aspects, the legal definition, the legal qualification, are partly connected, given that, of course, the law system protects the environment to a certain extent, as long as it has certain characteristics and extensions. By the way, to put it simply, as for the definition, and in light of the analysis of, I would like to suggest, considering some environmental acts and the European legal sources, such as the Directive on Environmental Assessment and on environmental liability. I intend, and I will intend during my speech, the environment as a complex system which produce ecosystem services, such, for instance, the forest that cleans the air, the landscapes, offers spiritual enrichment and intellectual recreation. Some fish species can provide water purification, and so on. A second characteristic is that environment as a legacy for the future. This, generally speaking, is what I intend talking about environment in terms of definition. The discussion on the legal qualification that I mentioned before is, in my opinion, more intricate. The most common qualification of environment is, and Marjan already said that, is that environment is a subjective right. This idea, this thesis opens the way for a protection mechanism that ensure a complete protection. In other words, subjective rights could be considered a sort of a bubble of immunity, you know. But a close examination of this idea, this postulation, often largely applied in the legal system and by courts, shows, in my opinion, some inadequacies. At least, remember that, technically speaking, the subjective rights, I insist on that, implies an absolute demand to live in a healthy environment. In Italy, for instance, that there is this definition, the right whose object is the healthy environment. And in other words, an environment that is beneficial to the owner of the rights and in line with his needs. In particular, also in Italy, but everywhere in the world, I would say, according to many decisions of courts, the owner of the right always wins. But this idea that makes the legal system very rigid, I think that could be considered in a critical way. Indeed, against this assumption, I would like to move these critical arguments, some different syndrome of paradoxes. The first one you can see on the left side, the syndrome of the tsunami. My first point is that facing the attacks of the nature, one cannot claim any rights. Instead, one is subject to the force of the nature and of its action. Mankind, in fact, is often attacked by the nature and its elements. And therefore, by considering this perspective, the reference to the right in terms, I repeat, of claims of the subject towards the nature seems to be naive or unreal, because the nature obviously is not obliged by the rules of the law. The law is a cultural build or cultural construction of human beings. The nature is not bound by this set of rules. I do say, this is my first point, that man is dependent upon the laws of nature, the rules of nature, in the sense that very often is the attacked part, is the victim of the nature, and in its relationship with the nature and the environment. It's the weak actor and subject to the nature, not the boss of the system. The second point below, the syndrome of the blank page. My argument is, if the subjective right were the dominant legal situation protected by this branch of law, the rules should somewhere express the relative protection. However, in my opinion, it's impossible to find such provision in environmental regulation in this branch of the law. Much more often or always, the environment is taken into account by the legal rules, by the environmental regulation for other purpose or other perspective, conferring some competencies, limiting the action of the citizens, preventing dangerous activities, establishing sanction, punishment, and so on. Where is the right within this context? This is my question. Of course, there will be a relevant objection. Sometimes the legal system, considering as well, or the case law, the jurisprudence too, gives an example of subjective right, this full protection, this bubble of immunity. Let's consider, for instance, the electromagnetic pollution or the other case of pollution. But my point is that in this case, and of course there are a lot of situations such that, the real object is not the environment, but health. Therefore, in other words, fortunately, there are many rights in our legal system, but this right don't concern the environmental balance. I said that the environment should be considered as a sort of it's an ecosystem, therefore a balance among different elements. The protection concerns the health, not the environment in terms of system or ecosystem. The third point, of course, there are some aspects in my argument that are not so clear, but I would like to provoke you also. The third point is the paradox or the syndrome of the crocodile, the poor crocodile that you can see there. If my argument is, if the purpose of environmental regulation were the protection of a healthy environment for mankind, then crocodiles, snakes, spiders, everything or every non-human elements of the nature that poses at risk to the health of mankind should be excluded from the sphere of this regulation. In other words, this seems to be the right subjective right perspective, a too narrow perspective, because it excludes or it doesn't consider other area of protection. However, it would be imprudent not to protect these species, also if they create a risk for human beings. On the other hand, generally, the protection of the environment does not mean or always mean the protection of mankind's health, such as in the protection of wetlands areas. So this is the third point, too narrow perspective if we consider only the idea of subjective rights in terms of healthy environment for mankind. The other point in the following picture, the paradox of the indiscriminate, impregnable stronghold. The right to a healthy environment, if this, of course, is the content of the right, is basically the reflection of the legal perspective of anthropocentrism. Mankind is understood as the world dominator, the dominus of the universe, transforms itself into the sole owner of a right, who wins at all times and in all cases. And nonetheless, the environmental system requires instead balance, flexibility, as required by the concept of ecosystem, not rigidity and verticality. For instance, given the variety of environmental issues, it seems impossible to imagine an identical position shared between all subjects. The management of environmental problems should take place in a context with which allows participation, dialogue, and the flexibility. The strong subjective right seems to be too vertical, too rigid, not in line with the idea of a balance and of an ecosystem that deserve a different approach, also taking into account the different responsibilities. Linked and very close to the previous these remarks, there is the other paradox, the other syndromes, the problem of the tree which falls in the forest. Does the tree which falls in the forest produce noise, even if not perceived by human ear? This is the point. This rhetorical question highlights the risks and the limitations of anthropocentrism. Once again, we are talking about anthropocentrism, and emphasize the tension between its legal transposition, because the subjective rights is nothing else than the transposition within the legal branch of the anthropocentrism, tension between this transposition and environmental needs, this flexibility that I mentioned before. The right could be referred only to the juridical sphere of the person, and so the use of this subjective right approach constitutes a clear tribute to the anthropocentric view within the environment, why many voices stress now for transferring the accent from an anthropocentric to an ecocentric approach. The point here is that by using the subjective right approach, environmental phenomena may appear important only if crucial or relevant to mankind. And this is not fair or enough, or even in juridical and legal terms. The problem of sublime, this is not a strictly legal argument, but I think that the legal approach should be in line with the common feeling, let's say, in this way. One can wonder, when considering the Kantian sublime, the majesty of the mountain, the depth of the mighty ocean, and so on, if the mankind is the actual master, the dominus, the owner of this world. Because as I said, this is the deepest meaning of the subjective right, at least considerably in a juridical right perspective. I instead think that the common feeling of the human beings facing the environment, in particular the sublime, therefore when they are present to a natural event or are contemplating a natural scenario, cannot be described in terms of claim to submit or to exploit the nature, such as the dominus of the universe. Rather, a different feeling arises, a feeling of respect and of liability, thus confirming that the proper approach to the problem cannot be found by emphasizing the right of the man, that's to say, I repeat again, is full and exclusive enjoyment of the nature. And it's interesting that again, considering the perspective of rights, and in order to offer protection to the non-human elements of the nature, such as the crocodile or any elements that is not human, very often, and also within the legal perspective, is said that these elements are the holder of rights. This is a very sensitive issue and a critical point. It's very common, the idea that we can talk about rights of animals, rights of trees, rights of the future generation, and so on. This is an attempt to provide a protection of these elements that are not included within the area of the subjective rights of the human beings. But I don't agree with this perspective, although I'm well aware that is a critical point, because I just forward and introduce this element. There is the question of the standing. Who can stand for the nature? Who can stand for the future generation? I mean, the many which probably put forward themselves as the more reliable protectors of guardians. My point is that the human factor kept away from the dimension of the holder of the rights, for instance, talking about the right of a dog and so on. So we can imagine to keep away the dimension of the human factor relevance. But this factor comes up when the problem of the standing to sue must be dealt with. When exercising the right, the need to identify a person, a human being that can claim the legal situation appears immediately. We can, of course, talk about a sort of non-human factors right, but we have to use a sort of non-technical concept. I would say a sort of a philosophical idea of right, not the right that I can trigger, that I can bring before a court to claim for a compensation, for instance, or a different kind of protection. On this basis, the idea of the environment as a subjective right seems to be very difficult to be supported. But the point is that the legal system is inspired to the personalist principle. The mankind is placed at the center of the system. Let's consider, for instance, the structure of many constitutions. The pivotal role is played by the person. So I think that we cannot suggest a definition of environment without considering the mankind and its central position in the legal system. The personalist orientation that is the core of the many constitutions oblige to stay within this idea. And the anthropocentrism, despite the rhetoric of the rights of nature, is the only reasonable and actually applicable interpretation in the law matters. But the point is that is not enough. The problem is due to the fact that anthropocentrism, when paired with the subjective rights, is absolutely inadequate. And so it's time to try to offer a different solution to the problems of the legal natural environment by, as I said, debunking the first myth that the environment is a right. From this perspective, I would suggest to shelve for a moment the juridical analysis and to undertake a methodological deviation. I think that it's important to see what happened and to consider the perception of the environmental issue in other fields of knowledge and science. In particular, in my opinion, it's important what happened within the philosophical field. But by the way, coming back to the point of the methodological approach, overcoming the rigid defense that separates the different disciplines, I think that also legal scholars may get from other science, other fields, new stimuli and topics. I think that it would be narrow-minded to presume that lawyers can deal with environmental problems and their definition by confining themselves to the ivory tower of law. We have to share experiences, to share perspective, and to consider what happened in other fields, what other scholars assume with respect to the environmental problems. And to begin with, one may consider how mankind is currently rethinking its role in relationship with the environment. This is important because there was, or we can look a change in the last decades. This is the final act of a complex and fascinating story that we, of course, might sum up only in its salient stages. But I think that if we can underline and identify the reason that have caused this change, could offer useful cues in the legal analysis as well. At least this is the direction of my research. So let's start considering the original scenario, because at the beginning of the history of our culture, at least in the Eastern, the Western experience, the history of thought has been characterized generally by a sort of anti-ecological attitude, or an evidently anthropocentric one. This attitude, the very beginning of the history of our culture, was due to these several reasons, of course, and we cannot consider all the points, but I think that a relevant influence on it has been produced by the religious idea of the human person that, at least within the Bible, is considered as the center of the universe. This conception, as I said, was especially suggested by the Western Christian thought. The man, image of God, who embodies the reflection, the image of God within the universe. And of course, from this point of view, the man considers all the natural factors are stretched at his feet. By following this approach, it can immediately be noticed that environment is nothing else than an element or a sum of components submitted to the man and to his necessities. Hence, the nature is not relevant in itself. Therefore, he assumes that it was relevant to the place of mankind, its role as a reconstruction and interpreted from the Bible. Mankind is at the center of the universe, which is at its service. The nature is subjected and to the man. The man is the projection of God. As a matter of fact, main indication in favor to the environment might be pointed out even within the religion dimension. Consider, for instance, the Eastern Christianism, which is more contemplative. The episode of the deluge, the flood, described by Genesis, where the man assumes a plain role of responsibility towards the nature, or against things of Saint Francesco de Assisi in his high sensitivity with regard to the environment. Therefore, a more proper and thorough consideration on the religious attitude as for the environment field shows that the dimension of its protection has always been present and relevant. Consider, for instance, the Laudato Si encyclical, the recent different attitude in matter of environment, in which the responsibility towards common good is stressed. But, however, the influence of the original idea, the thesis that I outlined before, is very strong in our culture. But nowadays the situation is radically changed. We are looking at or experiencing a decisive refocusing on ethics, in particular with regard to environmental issues in the last decades. Why that happened? The environment has been the object of very different movement. The environmental philosophy, the change occurred with the publishing of some important works. Some of them are indicated in the slides. Such a path reflects the image of an ethics that has become adequately equipped to cope with environmental issues. In particular, from the 60s, there have been stronger concerns over the future of the health, also due to the technological development. Of course, these concerns have contributed to a renewed interest in such a issue, because of course the risk related to the human behavior is an important aspect, and increased the awareness of environmental issue. And that contributed to shift the focus from mankind to nature. But I would like to stress another point, because this is very common approach, a very well-known evolution. I would like to stress the line of thought that prefers to find the argument useful for the individuation of the feature of a moral and the area of what is morally relevant. How can be identified the area of the moral, what is morally relevant? What is morally relevant is no longer determined by applying absolute and predetermined values to the concrete case, such as, for instance, the Kantian perspective. Maybe you know that according to this perspective, if the provision, the precept is not to lie, you must not lie to the thief who asks you where you hid your jewels. This was a very rigid approach, in the sense that the area of what is morally relevant could be identified by applying a sort of absolute value that cannot be challenged. But this line changed, and the point is that according to the hermeneutics, the relevant aspect is to consider a sort of dialogical perspective. This approach or attitude, I repeat, that gives value to the relationship between, because if it is a dialogue, there is the relationship between the subject and the other pole. The other pole is not existing in its objectivity, but depend on the relationship with the subjective. This is basically the hermeneutic, no? And that could be applied in many different fields. For instance, generally speaking, the experience is interpretation, in the sense that it has to do with the dialogue. And this is quite clear, no problem about that. But even science, even knowledge in general, have been involved in this idea. By rejecting the notion of truth as an objective datum that can be discovered in a neutral and totally detached way, many scholars acknowledge that the object changes according to who observe it. Let's consider the Einstein theory of general relativity. This approach move on or make us to consider that the objectivity doesn't exist. So the hermeneutic affected or had to do with experience in general, science, knowledge, but also, and this is the point that I would like to consider, the morality. From a moral point of view, the relation with the other, that means the respect for the other, ethics, consider moral the action that take care for others, that consider or look after their needs. You see another picture there, the great Levinas. Levinas says that the human face orders and ordains us. He calls the subject into giving and serving the other. The face traces where God passes. The fates, in its nudity, signifies don't kill me, protect me. Of course, this is a religious approach, but this idea that it's the face of the other, it's the other that is in front of myself that require the protection. This perspective has progressively widened in order to include, has been enlarged in order to include within the area of the moral, what is morally relevant, to consider and to take into account the other. Other might be the individual, the society, and finally, here is our last point, the environment. The other can be the environment, and the observation crucially allows to further enlarge the conceptual horizon and to see the connection between morality and the respect of the surrounding nature. This evolution has proved the moral relevance of the non-human elements of the nature that happen within the ethics. This evolution overtake the qualification of nature as things dominated by mankind, proposed a dialectical and relational approach inspired by the duty of mankind. And the duty are particularly relevant in the context in which mankind often plays the part of the aggressor, so the stronger part of the relation, or in which he is the weaker part, and therefore must use precaution. In conclusion, environmental issues have taken on a central position within the current philosophical debate, thanks to the extension of the ethical duty. And I would like to consider this point and suggest that in our little branch, the legal system, environment is the object of a duty. Of course, a duty is linked, related to solidarity, responsibility, and so on. Simply put, I would like to move from the anthropocentrism of right to the anthropocentrism of duty. No? And I think that the problem caused by the criticism exposed previously to the argument of the right could be resolved. Here you can see the summary of the criticism that I expressed. Tsunami, in case of environmental disaster, tsunami, earthquake, and so on, human beings are not the master of the nature. They are in the position of subjection towards nature. But that means responsibility, solidarity before, during, and after the disaster, and not. And this, I think, that is the most adequate words or concept to describe the protection. Nature follows its own rules. Mankind can influence them only partially, but mankind must live with an attitude of responsibility. Blank page. The positive legal system is literally imbued with the regulation that impose duty, limits, sanction. Sanction are the consequence of the breach of the duty. The crocodile. The protection of crocodile snakes is just justified. It's justified because we have the duty to protect the non-human beings too. Impregnable stronghold. The difference, for instance, between the kinds of the responsibility concerning different subjects is in this way explained. And the rigidity of the subjective right is prevented. The perspective also offers the interpretation of the feeling that mankind experiences towards nature, the sublime. And the idea is that in order to protect the nature or other elements, to protect nature here and now within the juridical system, it's better to use this approach of duty, real binding duties of solidarity. We don't need to confer rights to the non-human elements of the nature to ensure them a real protection. And there is another matter, I'm going to conclude, the principle of the subject at stake. Of course, you know the main environmental principle, but they reflect duties, not right. Those who pollute must pay. Damage must be mitigated at the source. It's necessary to have a cautious behavior. One must act in preemptive way. The impossibility to decline duties into rights confirm this principle into rights, confirm the necessity to forsake the paradigm of rights. These principles are a reflection of duty, but more in detail, they are the application of the fundamental principle of environmental law, that in my opinion is sustainable development. You can see here the definition of the Commission Brundtland. This principle, once again, cannot be understood from the legal point of view as rights recognized to people currently living. This is a duty, this is a responsibility, define the responsibility of the present generation towards the future generation. So that was the first point. The second point, very briefly, is that if the basis of duty stands firm, another different elements appears. If we consider the sustainable development, the sustainability, which is the pivot of this branch of law, it appears the ultimate purpose of environmental regulation is not the protection of nature per se, but the idea is to protect mankind's possibility of survival. In other words, I remain within this anthropocentric attitude. The regulation, in my opinion, is aimed at protecting the environment. Of course, I am well aware that it might appear astonishing and outraging. However, would it really be possible to imagine mankind accepting to safeguard the non-human species to the detriment of its own survival? In the case where there will be resources only for a species, do you really think that human beings will accept to be extinguished in favor to another species? But of course, mankind is well aware that in order to ensure the survival of its own species, the environment, the ecosystem, must be safeguarded. But the scope of environmental law cannot be traced within can be traced within the framework of obligation and solidarity. I repeat that this idea, according to which the environmental regulation is a selfish branch of law, is highly questionable and difficult to accept. The last point, I would suggest to detach sustainability, sustainable development from the environment by linking sustainability to a number of other sectors. My idea is that environmental protection is simply a part, a sort of tip of the iceberg, of a larger area or branch of law. It's the most example of this area, but it's not the only one. The fundamental cornerstone of this branch is the principle of sustainability, which expresses, as I said, a kind of intergenerational responsibility, duty instead of right. I think that this new sector of law could be applied where intergenerational responsibility arises, and then these are the main area. Of course, are the great problems of the modernity. The the plausibility of this proposal, I repeat, the progressive emergence of an autonomous sector of law having as its object the responsibility and the intergenerational responsibility, is supported by different set of considerations. First of all this area, all these crises have similar characters. Let's consider, for instance, climate change, immigration, financial crisis, energy crisis. They are global. Therefore, the first point is the globality, or in any case, no reducibility of problems on the scale of a single state. The widespread nature of the damage, the plurality of causes, the spatial and temporal disconnection between cause and effect, the information asymmetries, the relevance of technological innovation, the difficulty in identifying the most appropriate decision-making center, the need to organize differentiated responses, the impact on public budget and public administration, on justice and equity. Due to the presence of common characteristics, I assume that they might be considered as a part of the same branch of law. And we need a common theoretical filter from a scientific point of view. Another element, the tendency to broaden the concept of sustainable development. You can see, for instance, the 17 Sustainable Development Goals. They don't only concern the environment. The environment is very important, of course, but they cover different dimensions. That is a clear, expansive attitude. In many constitutions, sustainability now has been enlarged as far as including the public debts, any aspect where there is intergenerational responsibility. And the broadening of the application spectrum, the principle, in my opinion, justified the attempt to unify the investigation perspective. Not only intergenerational problems often arise simultaneously, are linked. For instance, the intertwining of climate change and immigration is very evident, or these problems are related to each other in terms of cause and effect. The war crisis generates environmental and energy consequences. The attempts to overcome the energy crisis produce environmental tension or significant food crisis. Consider, for instance, a comparison between COVID pandemic, a pandemic in the past, such as the Black Death in the 14th century. It's impressive because both periods are characterized by pandemics, climate change. Maybe you remember that the Little Ice Age was a period of cooling in that area, population growth, financial crisis, moral crisis. In that period, the Avignon papacy, when the Roman Catholic Papal residence relocated Avignon, the 100 Years' War. So there are very common characteristics that are impressive. Another common element is that very often these problems or their effects appear unpredictable. Economic crisis, financial crisis, health crisis, climate change, energy crisis. In reality, we often realize exposed that a more responsible choices in the past could have prefigured them. For instance, the earthquake. The other point, the management should take place at a supranational level, but is a clear local problems, kind of problems. So, as I said, the environmental protection to which the characteristics above mentioned are usually connected is only the tip of the iceberg. The other question, the first step of my research in the future, are, for instance, how to define the area, what operational consequences can be derived from the general legal principles. So very quickly, to conclude, I would say that, first of all, I said that these are problems of the modernity. I would like to focus this point also I am interested to know what do you think about that, because it could be objected that epidemic, wars, crises are so recurrent in the history. and they are not a prerogative of the modernity. But of course, the objection is correct in principle, but does not take into due account two facts. First, thanks to technology, today there is a greater possibility for men to aggravate and speed up the crisis. This character lacked, at least with the same intensity in the past. And above all, on the other hand, the environmental crisis, the paradigmatic example of the intergenerational problem, shows that unlike in the past, today we no longer have time. This is the point. We are as drivers of a Ferrari that runs very fast into a wall. And citing Heidegger here, just as the existence, the perspective of the being for the death of Heidegger, the existence is authentic only when it's traversed by the anguish deriving from becoming aware of our finitude. Also in the sector of law, these anguishes brings out the essential need to identify the real intergenerational problems and to set principles and rules that embody the authentic need to take care of those who are weak or to protect ourselves from those who are strong. That gives reason from the fact that the environment remains the driving factor of this new branch of law, because it remembers us the tragic incumbency of the modernity, deciding for death. The strength of the environmental issue forges the characteristic of the new law intergenerational choices. And the law tends to extend the scheme already used in the new field. But this is the second important consequence to identify the border of the intergenerational problems. My point is that when we are not placed on that intergenerational level of responsibility, when it doesn't come to this kind of problems, when the option don't have a real intergenerational death, let us live in peace, the main claim, avoiding the continuous, for example, functionalization of human action that some way transpire from a sort of rhetorical insistence of the environment. This theory, anyway, the theory that today I offer to your consideration, seems to me able to describe and explain the characteristic of environment and intergenerational problems. The last step, but I won't move on this point, is to identify some operational consequences, not only to describe. You can derive some real specific rule to be applied for the solution of intergenerational problems. That maybe could be the topic of the future speech, but there are some very important elements, for instance, in the jurisprudence of constitutional courts. But since I mentioned duty and responsibility, I think that now it's my duty to stop, not before thanking you for your time and your attention. Thank you so much.
Thank you very much, Fabrizio. This was really a great lecture, shifting the perspective from legal rights for nature to the duty of each individual to protect the environment. And I really would like to thank you for this very fundamental discussion. Thank you very much.
You're welcome.
That means that the recording will now be stopped.